The Leominster City Council meeting is funded in part by DeCarolis Insurance Agency at www.decarolisinsuranceagency.com and by Avidia Bank at www.avidiabank.com.
Okay, good. Good evening, everybody. This is a committee meeting of the Legal Affairs Committee. My name is Susan Shalafou-Zephyr. I'm the chair of the committee. Councilor Robert Tossi, the Ward 1 councilor, is on the committee, as well as Councilor Pauline Cormier, the Ward 2 councilor. So this evening, we are here to discuss petition. This is a public hearing. No, it's a committee meeting. It's a committee hearing. I'm sorry. Public hearing is on Monday. But we are here to discuss petition 9-26, and I'll read that. It is Susan Shalafou-Zephyr, Brandon Robbins, councilor at large, Ward 1 Councilor Robert M. Tossi, and 10 registered voters. Request to amend the zoning ordinance pertaining to MU2 zoning. And this was submitted for regular course on August 25th, and it's been given further time. We opened the public hearing, it looks like, on September 22nd, and that has been continued again to Monday, November 10th. And we do have a quorum of the city councilors here, so I will read this committee of the whole meeting notice that I'm required to. This notice of a City Council Committee of the Whole meeting is posted in the event that a quorum of City Councilors is present at this standing committee meeting. If less than a quorum of the City Council is present, no Committee of the Whole meeting shall take place. If a quorum is present, any such meeting shall be restricted to the standing committee agenda items listed above. So, with that said, I want to welcome our co-petitioners, Mr. Brady. Do you want to introduce yourself for the public?
Hi, Bill Brady, 214 Harvard Street.
Mm-hmm.
Donna Mollett, 58 Sky Lane.
Mm-hmm.
I did not sign the petition, not for any reason other than access up to it. I want to fully say that I support the petition, but I'm Dave Rollins, and the former Ward 1 councilor, and have a little bit of experience about Orchard Hill, both in 2004 when I got on, and 2013 when we approved the rewrite of the Leominster zoning that went on, which was a major ordeal that involved MU2. So
Yep.
hopefully provide some technical sort of background and detail on this when we get to it.
Right. No, as a former Ward 1 councilor, you were working on zoning for a very long time. I was here at the time and attended a few of the meetings. Councilor Rollins at the time worked hours and hours and hours on a zoning review. I did hand out some information. I just want to highlight that because as people talk and speak, these are things that you can refer to. So the first thing is it's authored by David Rollins. It's called Orchard Hill MU2 Zoning Density Analysis. This has a lot of very detailed information, but if anybody wants to understand how density is calculated, there are several examples of that. And then also it includes build-out scenarios. So what we're talking about in terms of, the total number of units that could potentially be built at this site. So that's the first document. The second document is a memorandum dated September 11th, 2024, from Joseph Boyle, the principal planner at MRPC, to Elizabeth Wood, the planning director of the City of Leominster, and I believe copied the Housing Committee. This was Mr. Boyle's recommendation, basically, and his explanation of why he was recommending changes to MU2. Following that is something called MU2 Zoning Suggestions from G. Lascotti, dated 29 August 2024. And this is a document from the Housing Committee file of documents. There are agendas and meeting minutes and all kinds of letters and other things. But this is this goes with Mr. Boyle's memorandum. And then the last, these are notes from the January 13th, 2025 City Council public hearing on petition, it was 1525, and that was the petition that proposed to change the MU2 zoning. And this is not a full chronicle, of that public hearing, but there were some questions that weren't answered, some other things that were a little misleading, some information that was missing, and that's really what I tried to capture in here. And I've recommended over and over again that people that are interested in this, and I recommend that they watch that January 13th public hearing. It's not very long. It might be a half an hour, maybe a little bit more, but it's really very informative. And I think that speaks to a lot of questions that people have raised about people voting for that particular petition. So with that said, why don't, Mr. Rollins, do you want to start and give some, oh, I'm sorry. Sorry, Bill.
Actually, that was a great lead-in you did.
Okay.
I thought it would be a good idea to show some clips of that meeting where it's very understandable how things might have appeared, how the city council came to their decision based on what they saw. And I think there's a lot of questions about the way things were stated, answered or not answered. So with your permission, I have some video clips. It's not very long.
Yep, no, absolutely. It follows really right after the Housing Committee,
Yep.
my notes.
Okay, yeah, it's actually pretty close.
Yep.
So I'll play a clip. I'm going to stop it and add a couple notes.
Mr. Brady, can I stop you for 1 second?
Absolutely.
Absolutely.
So this will be available.
Yes. Okay. Yeah, we can put that in the minutes. So we'd have to make the video available.
Yeah, I have it on stick.
Thank you, Counselor.
Should I charge you what LTV charged me? Just-
Maybe.
It was only 40. Okay. Did you hear?
We're still working on the housing crisis, so we're doing ways to increase housing.
I'm sorry, I'll try to increase the volume in that.
But looking at the MU2 district, this is an opportunity
Could we,
to increase the build-out.
is there a remote? Is there a remote for the volume?
Yeah, there was.
It might be in the podium. Did you take it on the podium? Did you pause it there?
Was it next to you? You had it earlier. Is there a remote?
No, over here.
I could probably put the microphone next to my player, but.
There is one around.
That might-
Yeah. Over there.
Remote?
Is it in your?
We had it moments ago.
Yeah. I did see it earlier. It's not on the.
Plus, I don't see it. I am blind.
The sound is coming.
Yeah.
Can you manually turn it up without a remote?
You can't, you have to have.
Yeah.
The remote was, that's how we turned it up.
We've regressed with technology.
Go look at your phone.
Yeah, sometimes you have to
He
ask.
just had it.
Let me call my grandson.
And then we need to put an air tag on it.
TV on.
I thought the LTV cable had to stay. All right, well, while we're looking for the remote.
Oh, you got it.
Oh, good, good.
It's not done remote for it, but it might work.
Thank you.
All right.
Perfect.
Small miracles.
You might have to adjust.
Might be streaming now. Yeah, it might be.
I might be on full blast.
Sorry, technical difficulty.
Bill, could you just introduce each clip before it starts?
Oh, sure. This one is Elizabeth
Still
Wood.
working on the housing crisis. We're looking on ways to increase housing in Leominster. We're rather limited. But in looking at the MU2 district, this is an opportunity to increase the build-out, more building permits per acre, without impacting other neighborhoods. If you look at the zoning map and where MU2 is located, it's near the commercial area at Orchard Park. And there's city-owned land buffering this from neighborhoods. There's wetlands that will have to be buffered when this is built. Plus, if you look at, I know you've read through this, you may have noticed that the planning board has discretion to add a 50-foot buffer between the MU2 zone and surrounding neighborhoods. There's no longer, when MU2 was created, I believe there was a greater demand for commercial. That's no longer. We have a demand for housing, and this allows for that.
Okay. Just a couple notes on that one. You notice that she said there was city-owned land, which is actually the Leominster Land Trust. It's not city-owned, and it does not buffer between that and the neighborhood. It's a direct coalition. You saw the plans.
I'd like to make a few comments on that. First of all, I think it's very confusing during this meeting whether we're talking about a project, which is only 17.95 acres, or you're talking about the MU2 zoning, which is what you're really talking about, which is 120 acres. And when you're talking about density, it's in the context sometimes of only this 17.95. And so the impact of changing density, substantially changing density, the by right density went increased by 75%, from 12.4 units per acre to 21.8. That doesn't seem so big in the context of a 17-acre project. But if you look at a 55-acre subdivision, which is only one of the subdivisions up there, 55 acres times an extra 9 units per acre adds 450 units just to that subdivision. So it's important in the context of this, and I think that's lost in this meeting. You're not talking about a project, you're talking about the whole zoning district.
I just felt it was important to highlight that one of the first sentences is talking about that it's not going to impact the neighborhoods. And I don't know what the analysis is where that came from, that the decision was made that increasing the density and increasing the building opportunity of housing, high-density housing in this, and changing this zone would not impact the neighborhoods. I didn't see any sort of impact study that showed that it would not impact the neighborhoods, but that was what she led with.
One other point, if I may, and this is more subtle, the discussion about when Orchard Hills was built out, it was about commercial. That is absolutely not what that was all about. That was developed under mixed use. The commercial was the means to the end. It was industrial zoned land. And we needed commercial to bring the infrastructure into that zone, and it was limited to only 30% of the land mass. The 70% was to be industrial. It was never, developers who developed Walmart changed the zoning, which changed that game and ruined mixed use. It allowed it to be 100% commercial, and I won't go how that's done, but I could. But the main point, so that's another fundamental issue. This was, even when back in the day, it was never supposed to be this gigantic commercial build out. The commercial was the means to the ends to bring the infrastructure for the industrial development. Thank you.
Okay. This next one, I just want to bring your attention that she assured all of you that this was much vetted, so.
We worked closely with the developer of the property owner of the MU2 district and also the planning board on this. So it wasn't, it's evolved, it's been vetted, and this is the final product from that process. And it comes before you. So at the beginning of the petition, you'll notice number 1, the first change being suggested is to amend the table of uses to replace the entry for apartments, multi-use dwelling under District MU2 to read yes. So I believe that was a no before, now it's going to read yes. And then there's some changes in the dimensional regulations on the dimensional chart in the zoning ordinance. I'm not going to go over all of them, I'll just give you a brief overview. We're not changing the frontage of any of this, except for non-multifamily. It used to be 30, it's now increased to 50 for multifamily dwelling units. So that has increased. And we've reduced some of the side, front, and rear setbacks on some of them, in some instances. But we've retained the height requirement and the number of stories. That's not changing. So that will be the same in this amendment if this is adopted. So moving on from the use.
Just, did you want to?
When this particular clip is played, I'm not sure if anyone else can clearly define what some setbacks on some sides are.
I have no idea what that meant.
And so I want to bring that forward, that it lacked definition. This particular individual breezed over the table, which impacts so much for our city, that some setbacks change somewhat on some sides. I think it would leave a lot of people confused.
Yeah, perfect.
I'd like to make a few
Yep.
comments on that. And this may be, we could talk about this more in summary. I think to send Ms. Wood down on her own to do this was a huge mistake. And there's plenty of notes to show that, in fact, in the November Housing Committee meeting, the head of the chairman of the planning board says that the developer is already working on his plans, and this was in November of 2024. So by January, they had a pretty good idea what's going on. So the point is, in my view, transparency would have been come down here and say, this is what we have for the project. Bring down the petition, the person that wrote the petition, developer, whatnot. They should have been here in an open process and said, this is what we want, and this is a project we want to build, and these are the zoning changes we needed. That's transparency. That didn't happen. And I think the difficulty here is for some of the explanations. Having said that, there's a couple things. First of all, and I think it was corrected in a meeting, but the multifamily was not a no. It was a special permit by the planning board or site plan approval, which is kind of confusing in itself. And then it had a footnote to see the regulations in section in footnote number 2, which sent you to the regulations. So residential was allowed. It was not changed from no to yes. It was changed from low-density residential was allowed by right of 12.4 units per acre. A special permit was required for high density of 17.4, and the request in the petition was to go for an even higher density by right of 21.8 units per acre. So there's as much not being said that's important to making this decision as to what's being said and may be incorrect. So very clearly, the special permit for density was removed, which was a big deal. I don't think the developer would have been worthwhile for them to develop in the lower density, so it was almost mandatory that he would have had to come for a special permit, which triggers a whole set of things and gives you a lot more power to have a say as a neighborhood. But more importantly, the end result of this discussion was that by right, he had the ability to add 21.8 units per acre, and that's not clear in that discussion there.
Dave, I got a quick question. What is the vetting process for the planning board? Like, what does that involve? Do we have any ideas what that is?
Well, I think if you really want, unfortunately, I don't know, I wouldn't say unfortunately, there was a housing committee that was established with this, and you can go on a long discussion there, but some vetting was done there, and I have the minutes. It's not much, believe me when I say it's vetting, and this is what leads to this whole discussion about the 2 handouts that you had. They met for the first time on the 29th to discuss MU2, and I don't know, you want me to go down this sort of?
Yeah, I think you should.
Okay, so on the 29th, the housing committee, who was basically looking at housing in here, met on the 29th of September in 2024. And that's the first time, you can go through the minutes, basically the owner of the property notified the housing that he had interest in putting housing up at his location in MU2. And it's not in the minutes. I stumbled across this. A few of us that were doing sort of research on this stumbled across this, but the document that you have in your hand is the suggested zoning changes to MU2 that was presented on that day by the developer. You won't know that if you read the minutes. They're not, this document is nowhere referenced in any minutes at the Housing Committee. Then, 13 days later, you'll see that Mr. Boyle's document on the Massachusetts Regional Planning Commission document, you'll basically see that this is almost verbatim what the developer gave them 2 weeks earlier. And it's not, again, there was no housing committee meeting in between there. It was somehow Mr. Liscotti handed a thing saying, these are my wish list for changes that I want in MU2. And these are substantial. And 13 days later, there's a cover letter from the Massachusetts Regional Commission that says, you know, our investigation in the MU2, these are what we think are suggested changes. And they're, I mean, other than one small detail, these are verbatim. So having said that, they met the following month, and there is some review of this document or vetting. And the only reason I know that is because I mentioned this is because in that meeting, Claire Frieda, who was a member of that, it was in the meeting, and she said item 4, which was so she must have been referencing Joe Boyle's document, because they're talking about item 4, which goes to the next point here. Item 4 was not added by Mr. Liscotti, was not a suggestion by Mr. Liscotti, and what that was anything above 20 acres needs to come before the City Council in MU2 for approval by the City Council. Mr. Boyle added to Mr. Liscotti's suggestion that he wanted this to go before the Planning Board and not before the City Council. And Claire said, no, it needs to go before the City Council. That's the only reason I know that there was any vetting of these suggestions based on the notes in there. That's the only connection that I could see. And then the only other meeting, reference to this is in the November Housing Committee meeting where Boyle says there's a potential for a lot of units, and Mr. Souza stated that he expects this to happen. The developer is already working on the plan. And that is the the conclusion of the entire Housing Committee's reference and vetting of MU2. You know, this project in MU2. After that, I don't know what the process is.
So it's almost impossible to make an intelligent decision on anything here.
Well, these guys have done a lot of work. There's been a lot of homework done to get to where we're at here, believe me.
So there's going to be a couple of these clips in regards to the 20-acre.
Any project that is going to have more than 20 acres or more is going to have to come in front of the City Council for an informational hearing. That hasn't changed. No, the City Council doesn't have any voting power over that project. It's an informational only, and it'll be the discretion of the developer to take comments into consideration or not.
So,
Sounds like the developer's running the process here.
well, said to the City Council that it's at the discretion of the developer, which I thought was interesting. This next one is very, very important, especially to our group and the people that live on Harvard Street and are going to be really affected by this. Please listen to this.
It allows for housing. It does not impact adjacent neighborhoods as some of the other proposals that come forward might have done.
It does not affect neighborhoods. That's what you were told. That was her testimony.
I just want, and to accentuate that point, again, we're talking about the entire MU2 district. We're not talking about one project. We're talking about, there's approximately 82 acres of undeveloped land left in this 120 acres. One subdivision that's been filed is 55 acres, the other subdivision is 27 acres. If you do the math on the density of 21, now we can get into deeper weeds, but just to give you a scale and size of what we're talking about here. If you're talking about 21.8 units times 55 acres, you're talking well over 1,000 units. By right, in that one subdivision. How anybody can make the statement that this is not going to have an impact not only on the neighborhoods, but Ward 1 traffic alone. You won't be able to get out of Lawrence Street in any of these places.
No chance.
So I'm being kind at 1,000. It turns out the math is like 1,200. Now, the 21.8, because this was brought up during one of the debates, the first 17.95 acres that is before the planning board right now for site of plan approval is 294 units, something like that. It's not at the 21.8 density because there's a pool, a clubhouse, and all kinds of other things. But in the 50, that still leaves 37 acres in subdivision 1 that are going to be built out. And how do I know that? Because if you look at the request that was put forth by Mr. Liscotti, he wants the removal of the requirement that was on there, which was you could only build housing on 1/3 of that lot. So he was limited to 40 acres. He asked on his wish list to get that removed. That was removed. Now he has full residential access to build that out, fully residential. So 55-acre subdivision, he's telling you in his wish list that that's what's going there, because industrial's not going there. I'm telling you, I've been 25 years at looking at this site. Nobody's building industrial to compete with commercial or high-density resolution property.
That's the next clip.
Okay.
Yeah. That's a good segue. This next one, you're going to see that there's a lot of confusion as to the 60% rule. And it's also stated that the chairman of legal affairs at the time was under the assumption that the shopping center as is took care of the 60%.
Well, another hurdle that has to be met before you can move forward with a multifamily zoning under the MU2 district is that 60% of the non-multifamily must be built or...
Are you talking about section 28.2.1?
Yeah.
Yes.
I believe that is in there, and
It's being deleted.
it's been deleted because that's no longer,
Well, I would assume that that's been met with the shopping center.
we haven't had a mathematical calculation on that, but it has been close enough.
So the clarity on that, because there's 2 points. You want to make your point?
Go ahead.
So there's 2 things that are talking about in terms of this thing. So there's one rule that said no more than 1/3 of this site could be developed as residential. That's 40 acres. The second rule said that you had to complete 60% of the non-residential development before you could start the residential. The idea is you didn't want to declare something to be mixed use and then you just put all apartments on there.
Like what's going to happen?
No, in that, by the way, counted the stores. So as you can see in this discussion, they're saying, okay, it must have met the 2/3, the 60% must be met with the stores. Actually not. The retail accounts for, and I don't have the exact number, but the retail accounts for under 40 acres, maybe just under 40 acres. And the reason for that was because the original zoning of mixed use limited commercial to no more than 30% of the site. So the 60% rule is not met with the existing stores. And that, by the way, that gives you a pretty good insight of what kind of scope we're talking about of this place. If the stores that are up there now make up, again, I'm not exactly sure, but if they make up 1/3 of that site, and they make 40 acres, and now you're talking about apartment complexes that could be built by right on a 55-acre subdivision and a 27-acre subdivision across the road, you get a scale of how huge this place has the potential to be by right.
Let's see, the next one, you're going to hear some testimony as to the wetland system, natural buffers, between the project and adjacent properties. She assured that it was a 50-foot buffer. It's actually 30, less than that. And that actually, through the planning board, it almost looked like the developer said, okay, we'll give you 50. She's telling you that it's 50.
I really don't have a big concern about the buffer or the setback, the discretionary with the planning board when it comes to the portion of the site that may block the shopping center, but I am concerned, obviously, any residential area may be coming up against, but I did walk the site back in October, and there is a significant wetland system that almost runs that entire boundary in the back, what I would call the rear, so farthest away from the shopping center, which provides a substantial natural buffer. But so you have indeed, the recommendation here is to reduce the buffer that's currently in the book from 50 feet to 30 feet. So it's a 20-foot reduction.
Well, if it's between MU2 district and adjacent districts, it's still at 50.
Okay.
This is within the MU2, it's 30 feet, so it's the same property owner
So when we
within
get,
the district.
so when you get to the residential boundary outside the district, it's 50.
50.
Okay. All right. Thank you.
Watching this, if I was on the receiving end of this in early January and I was sitting and deciding which way to vote on this, it seems there's a repeated pattern of downplaying what is really happening. It seems that, it's just 30 feet. It's, we didn't really do the math. It's some setbacks on some sides. And I think it would make it very hard for me to make a qualified decision on what I was actually electing for this particular zone. And I think it's important that this is just small pieces of a consistent pattern throughout this testimony. And I don't in any way hold any blame against the individual that was forced to deliver this information, because I do think that, I don't want to say she was set up, but she was put in a position where she wasn't provided with enough information to articulate what was really being proposed to you.
So on the buffers, so we got this huge density issue, and now we're going to play with reducing the buffers. So the actual law that changed that's trying to be reset with this ordinance is that it used to be a minimum of 50 feet, and I think you could have gone as high as 100 feet. So if you look at when I was on the committee, what we did in terms of the whole zoning overhaul and what we allowed, it was still a very substantial project, very substantial. But it was nowhere near enough for the powers that be here. And one of the changes is that it went from a minimum of 50 feet. It could have had easily just said, no, we want a 100-foot buffer under these other densities. But no, now we got this super max density, and the maximum is 50 feet. And in fact, one of the meetings, which I've been to a lot of hearings on build-outs and whatnot, one of the meetings, they showed up with a 15-foot buffer and put up a slide first showing 60 foot. And one of the neighbors like, this doesn't make sense. And he said, oh yeah, where's the property line? 40 foot of that picture was the abutter's property. They were counting it as part of the 60. The reality is, with the zoning as it is now, the best you can do is 50 feet. But the developer showed up in many cases with 15 and 20 feet, and it took a lot of work by the neighbors attending en masse several meetings to the planning board to get them to push it up to 50, and there's still a section that's not 50. So that's just not right. I mean, a project of this scale and this size has the ability today under existing law to show up with a buffer of 5 feet, 15 feet, 20 feet. I mean, we're talking hundreds and potentially over 1,000 units on one location, and somebody could have a 15-foot buffer. And you got to fill this room up to get changes to bring it back up and say, hey, why don't you make it 50? That wasn't easy. I'm sure you've watched the meetings. That wasn't easy to get back to 50, and that's the best you can do.
Okay. So this next one, let's see. The planning director is asked directly about potential units. And a follow-up to that, you had asked the question, and you had said one road in and one road out. And by a head nod, that was made. It's not the case. There's an exit coming out on Harvard Street on this one, but this is what you were told.
How many potential units do you think we're going to be increasing this development to? Any ideas?
I can't say we have a build-out analysis. That's something you can do. You can get a build-out analysis. We did not do that. And there's options. They could build townhouses. They could build apartment buildings.
And there's only one way in and one way out, I think. There's only one road that all this is going into, correct?
Mm-hmm.
Thank you.
That kind of speaks for itself. Yes, sir.
Quick question. That second road, wasn't that required by the fire department for access?
It was recommended.
Recommended?
To, and it does cross over some vernal pools, and there's still some stormwater things that conservation is taking care of it. It could have been emergency use only, but what I'm saying is this made it sound like everything was going to come in on the new road.
On the mall side.
You know, on the mall side.
Yeah.
That's what you were presented with when you did your vote, so I thought that was pretty significant.
Okay, I just was curious because I think in the original presentation it was just one road there, but it was changed by the fire department.
Once they got a copy of the plan, of course, this one, the plans weren't done yet. I'm sure they were done, but I don't know if they were submitted. But, you know, I mean, you were voting on a whole zoning change, not just that one project.
Right.
But you were assured that it was one road. So I took it at its face.
Now, knowing what we know now, shouldn't they have that right on the tip of their tongue, how many units that they're going to be? I mean, come on.
To me, that's the most egregious. The density is, to me, the most egregious.
What's the legal opinion on this?
In what respect?
Well, geez, we're asking for information that we're not getting. So what's your opinion? It's okay?
Yeah, I can't offer an opinion on that. I mean, developers come and people present things, and sometimes they choose to present more, and sometimes they choose to present less. I've seen it done all different kind of ways.
The issue here, though, to your point, I think, I think this is the most egregious because I think the information that wasn't presented to the council on that question is I think would have been would have changed a lot of minds. And to this point, this is a math equation, right? So the way it's done in the zoning book is you have how many square feet per unit. An acre is 43,560 square feet. You divide it by the number of square feet that you need per unit. So when it's at 3,500, you do the math, that's where you get the 12.4 by right. So now when you want 2,000 square feet, which is what they had to change to, you do the math, that's where you get the 21.8. So if you're in the planning business, right, this is fundamental. Density is fundamental concept of planning. So when I say to you, how many units, I don't know what they're going to actually build. So the question of, and he's not building townhouses, he made that clear in the housing committee meeting, which these people were all there, but put that aside. The question that you're voting on is what are you allowing by right? That's really what's on the table in terms of how many units are we talking here? So how many are you going to allow by right? How many acres are undeveloped? 82. Do the math. 21.8 times 82 acres. Now there's wetlands and there's buffers and there's areas that you can't build. So you're not going to build 1,700 units, but you get an idea of the size and scale of this place by just doing answering the fundamental question. How many units? If you would ask me that question today, after I sort of tried to spin up on being into planning, I would have said you added 9 more units per acre by right. Do the math. 55 acres, 450 units on that side of the road, 27 times 9, another 250 units on the other side of the road. Added. Not full project, added. That's the answer to your question, and that puts this whole thing in perspective, I think. And like I said, a lot of this is what's not said that is
I would
what
think
makes
that
it
should have been
difficult.
part of the vetting process.
But Counselor, if I can speak to your previous question, I think that there was more than one instance, your question as well, where it keeps on being referred to as a project. It was a zoning ordinance change for 82 acres. So we don't know yet if it's one road in or one road out. That land abuts more than one street. And I think that that was part of what was allowed to be very confusing. It's not a project. Of course, they don't know how many units yet. Look at Dave's math. It's easy enough to figure out what you are actually approving when you consider its zoning and density allowance, not a project.
Okay. Quick question. As far as the current development goes, changing this back to the MU2 with the more restrictions on it, will it affect that project?
No,
No, so that's done.
And he submitted subdivision plans that could put a place marker on it for another 7 years.
2 more additional roads to nowhere.
Okay, well, further question is, changing this, I think would make a difference, but could you change it to possibly a different, this is kind of off the wall, but, could you change it to something like residential B, which has a much lower density requirement?
For
the rest of the land.
The point would be moot because it's MU2. Every bit of it is MU2.
But I'm saying instead of changing it back to MU2, change the rest of it to residential B. Could you do that?
I don't think that's realistic, and I'll tell you why for a couple of reasons. First of all, this petition that's before you resets it back to what it was.
Okay.
Still substantial, still big, still has, but it sets it back to what it was done in 2013 and the way it existed for many, many years. Immediately after that, the landowner filed 2 subdivision applications, preliminary subdivision applications. And I don't think you would have seen those subdivision applications if this petition was filed. If it wasn't filed, you wouldn't have seen that. That was only done because he has 8 years of freezing that zoning so it won't be touched. But he has 7 months to come up with a definitive subdivision. Now, what he's saying is, I don't know what I'm going to build on the other stuff. And there was a long discussion about whether he should be required to do a development impact statement, which is a legal, detailed document that can be may be required by the planning board. Doesn't look like that's going to happen here. So it might be done at the definitive, which is 7 months away, right? So I think there's some potential legal issues there. But for me, modifying this zoning back may or may not affect this project. We can have, it's not going to affect the individual 17.985 acres, but it may have some sort of impact on the larger, but let's put that aside. You are setting a precedence in this city for zoning that, in my view, is extremely dangerous. You're saying 21.8 acres of density is allowed by right in MU2. Anybody that has MU1 zones in this city now are going to be asking to be MU2. Anybody that has industrial land, they're going to be asking for MU2. And another thing is, you set a precedence that says, hey, you can submit your wish list. Come to Leominster, submit your wish list for what you want for zoning. We'll get it done. I just think that's a really, really, really bad message. regardless of whether these zoning changes impact Orchard Hills or not, I would not leave MU2 on the books as it exists today. There's no way. That is in my view, a terrible precedent for how it happened, for what it sets for a precedence for this city. That is just too much, and it was done with the intent, if you watch that meeting, with the person that was hired as a consultant, to take the people's voices out of it. If you represent your constituents and you watch that video of that conversation, I left at like 11:30, it was late. That conversation where he basically says, as a consultant hired by the planning board, who was basically running the show, who wrote the document, who wrote the zoning document, and he says, basically, yeah, we took the special permit out because we want the voice of the people that live in this city.
Dave, I have that clip.
Okay.
You want to listen to it? Unfortunately, I couldn't download it.
Don't let me describe any movies to you, because I'll give the plot away before it happens.
To remove the special permit requirement for the same reason that the state removed the special permit requirements in the MBTA Act and from the ADUs. Because with that special permit requirement there, the neighbors can show up, they can make a lot of noise, and the board can cave to them, and the housing doesn't get built. It was important to remove the special permit requirement for the same reason that the state removed the special permit requirements in the MBTA Act and from the ADUs. Because with that special permit requirement there, the neighbors can show up, they can make a lot of noise, and the board can cave to them, and the housing doesn't get built. It was important.
Now, this was Joe Boyle at Monday night's planning board meeting. Okay.
I knew when we signed this petition, it would not affect the 308 at the time, 17-acre, high-density, environmentally crushing housing project that this permitted, but I knew this is not okay. Now that I saw the individual who was hired by the planning board to put forth these recommendations, specifically did so with the intention of removing neighbors from having a say in any part of this process, I know we were right in asking this opportunity for you to not let this happen for Leominster. It sets a very dangerous tone and precedent for all of the rest of the city.
And I want to add to that, because this is really important also to this. There's a myth out there that you can't have housing in a special permit. And it's a myth, and it needs to be busted, because I believe developers are driving that myth. And the reason I say that is, if you look at what was allowed at this site before 1525, it was substantial. It was substantial. It wasn't about, this isn't a choice about no project or a huge project. This was a choice of a very large project and now, massive project. There was nobody that I've met in my discussions with people on Harvard Street, anywhere, that say, no, we don't want any housing. I remember the discussions when we had developers down here, including the landowner, as part of the big discussion down there. We agreed that some form of residential should be allowed down there. That's why we made that change, and we all sacrificed. It wasn't like anybody, the idea that I wrote it, somebody made a comment that I wrote the MU2, believe me, I didn't write anything. We reviewed it and we updated it, but there was a lot of give and take. A lot of give and take. I would have never given up special permit from the city council to the planning board, but I had to. That was the will of the council at the time. So there was a lot of give and take. You don't pass a 200-page review of a document without give and take. But my point is, there was a spirit of housing to be there. This is not about no growth. This is not about zero housing units there. This was about a substantial project that when you went to high density, you had to let the neighbors have an input on it. That's what the original zoning was all about. And that wasn't enough. That wasn't enough. It had to be more and more and more. And now they have no voice. You don't have a voice. Before you had a voice in high density, now you have no voice. Because this myth that's promoted out there that special permit won't make it work. That's ridiculous. These people have their lives tied up there. There's a woman here. You watch that meeting. That woman could barely walk. She walked those streets knocking on doors to get people to sign a petition. I mean, this is a big deal. She walked all these streets. I feel so bad. And she came at the wrong part of the meeting, so it was a little bit confusing. I'm like, just take this woman's signatures, please. Because it's real for these people. And to say, oh, it might cause a delay, or it might be take too long if you have a special permit, that's just not right. Not on this scale. You know, if you're talking 20 units somewhere or 50 units, by right potential to build 1,000 units in somebody's backyard, and you don't want them to have a voice in it? I mean, okay.
We'll move the point.
I'm trying to keep hitting
Bet
me.
you wish you could do that when he was on the council.
Believe me, I did this. Those guys that complained, don't worry.
Okay, I'll let you see this one.
More than 20 acres?
Yes.
I'm going to go right into the next one.
Yeah, 28.2.1, the multifamily housing component of a mixed-use project may not commence until the non-residential portion of the project is at least 60% complete, taking into consideration buildings previously constructed as part of a mixed-use project. So actually, it's not as stringent as I... Okay.
Yeah, do you want me to do that right now? I can find out in 3 minutes.
Okay, they were asking about density there, and she didn't have the answer. But Councilor Cormier, you asked directly, is this over 20 acres? And you heard her answer. It wasn't, broken into smaller parcels. So again, all these things is not to put the spotlight on one person. We said that. It's just to kind of show you that how it could be misconstrued, how it could be mixed up, how you were misled. Okay, so this next one, I'm going to play it again because I think you'll follow along with what it.
I just looked at the GIS quickly on my phone.
Thank you.
It looks like, so don't take, I might have missed some, but just at a quick glance, there's like 1, 2, 3, like at least 6 parcels that I found. 12.45 acres, 11.27 acres, 17.95 acres, 13.64 acres, 9.84 acres, and 4 acres. So it's not one big parcel of land legally, so none of these would trigger over 20 acres or more.
Well, Mr. Scotty isn't here, so I don't want to envision what he might bring forward.
Right.
But he owns all of that, so the project might be bigger.
Right, that's what I was
I
wondering.
think he's envisioning bigger than.
Would you combine all those lots because the way they're broken out, not one of these lots is over 20 acres?
That would be
Okay, so you were kind of led down there saying that it would be considered as one. This clip will prove that.
If I may, in 28.2.2, says a site on which mixed-use project is undertaken may be made up of parcels in separate ownership, but are considered as a single lot for the purposes of all uses, dimensional, open space, landscaping design requirements of this ordinance, including yards, setbacks, buffers, the number and design of parking spaces and areas, location or design of driveways or interior drives, and location and quantity of open space. So they're taken, obviously they're taken into account for the MU2 district combination of parcels.
The whole district. The whole district. Okay.
Correct.
Gotcha.
And even separate owners, but in this case,
same owner.
same owner.
So if I was listening to that, I would say, oh, okay, we're going to have a chance to be presented with this project. I mean, any reasonable person would. So now,
But that was eliminated.
No, it wasn't eliminated.
That
So the zoning ordinance says that any project 20 acres or above
Right.
has to come before the city council before applying for site plan approval or special permit. Now, the attorney knows my objection to his interpretation of this. I disagree with the ruling that this, basically the 17.85 acres is the project and under 20 acres and therefore not subject to the 20-acre rule. I think the filing of the subdivision shows that the project is really a 55-acre project. Then we get into the discussion of, well, the subdivision doesn't require a special permit or a site plan approval, so therefore it's not. And I raised the argument that, you know, A is, well, you know the argument. I don't know if we want to go down there, but I don't know. I'd be curious because we didn't get a chance to talk about it the other night. You know my position, right? That the statement in the ordinance is just a statement of ordering that says you got to go before the city council for a project about 20 acres before you do this, right? It does not say. So you have A and B. It does not say B is a dependency of A. In other words, it doesn't say that the project has to have a site plan approval or a special permit to go before the city council. It just says a project of 20 acres has to go before the city council before you apply for anything else. It doesn't say that that project has to have, a project that requires a special permit or a site plan approval that is above 20 acres must go before the city council. It doesn't say that. So that's my, you don't seem to understand my position.
I follow it. What I would say is before could mean at any time. In other words, my interpretation of it is it doesn't get triggered unless and until somebody comes forward with one of those.
With one of what?
A site plan or a special permit. In other words, if I came before the planning board with a site plan that showed a project of 30 acres, the planning board would say, no, we can't accept that application until you go before the city council. But you may be right, but what you know, they may never come forward with a site plan or a special permit.
So if I have so
let me finish. So you could say that about any parcel of land, right? You could say, well, maybe there's some other parcel of land in the city that maybe someday somebody will come before with a project, and so you have to come now. But I understand what you're saying, that you have to wrap up the subdivision into that, and I just maintain the position that until there's the hook of a site plan review or a special permit, it just doesn't trigger that section at all.
But all the property is MU2 zoned. That's the macro of it.
No, I understand that. I understand that.
Any reasonable person would say, okay, this is MU2, we've got to take it as a whole.
Take what as a whole would be my question. Take what as a whole?
The development of it.
The development, right? And the development is defined by whatever comes forward as a site plan review or a special permit. Then that's just the way that we read it.
So quick question, if I have a 40-acre project, I don't require any site plan or special permit, do I have to go before the council?
So it's just totally as of right?
Yeah.
With no site plan review or a special permit?
Yeah.
No, I would say no under that reading.
But the ruling says any project above 20 acres must go before the city council.
Before a site plan, so if there's no site plan approval, it sort of gets metaphysical, right? It almost gets philosophical.
Okay.
Right? What I'm saying is, the trigger is that before language, right? Before one of those two things happen, this has to happen. If the two later things don't happen, then the first thing doesn't have to happen.
Okay,
That's the way we read it.
I just want to get back to my point that we were led to believe it would have been reviewed based on the testimony. This final one, we all miss Peter a lot, but we all respected Peter, especially when it came to wetlands and conservation. He was a leading voice. He stopped a lot of projects that would have hurt wetlands, and I'll let you. I can't know what he was thinking at the time, but in his heart, I think he thought we were protected.
Yeah, I looked on the GIS map as well. I believe the land in question, that is MU2, comprises 17.95 acres of land on the backside.
That's the inside.
Well, the parcel that's not developed. That's, to be more accurate. Much of it's developed by the Orchard Hill Park, but the undeveloped portion, that big lot in the back there of where Target Dick's would be, that's all, that lot's 17.95 acres.
So the developable portion of that lot would be even less because it's encumbered by a significant wetland. So, well, that's helpful.
Just one quick note, just so you know. That 17.95 acres is part of the 55-acre subdivision. So when we're talking about, oh, it's just that undeveloped lot at 17.5, if you look at the subdivision, there's two subdivisions that were applied for. One's 27 acres on the other side. This one on this side is 55 acres, and that includes the 17.95 acres. So the idea that we're talking about this big lot behind Target that's 17.95 acres, no, it's 55 acres.
So, obviously, those are my outtakes of the meeting. I would encourage everyone to watch the whole thing, but these, to me, are very significant in basing the decision to try to reverse the MU2 zoning. It might be academic at this point, but as David said, we can now see what the MU2 zoning can produce. Do we want that in any other areas of the city? I guess that's what you have to ask yourself. If you bring it back, they can still develop it. It's just the abutters would have a little more input. You would have a little more input. This whole project just felt like it was manipulated and thrown down our throats, like you have nothing to say about it, even though it's going to affect our neighborhoods, right? Everyone's, it's not a total NIMBY thing. When I voted for that road to be developed, I was assured, and Frank, you were at the meeting, there was a lot of, I looked right at Mr. Lascotti, and I was assured there would be plenty of buffer, a lot of buffer. And then it was just eliminated. So I felt we were a little misled, and I just hope other people in other neighborhoods in the city don't have to feel like this.
Well, thank you for the time and review of this petition. I know on its surface it might seem academic, but it is, as we have asked you to consider, it's a much larger concern. The opportunity to make sure that this is not a precedent for the city of Leominster is what's before you. It's not undoing what was done because you didn't understand what you were voting for. No one is saying that. I think we've highlighted where it could be, you could make an argument that a lot wasn't said. I do think that the planning director was put in a position where she didn't have a lot of answers and she did the best she could. I know after watching those clips, I would not be able to make an educated decision on what I was actually voting for, but it will affect others down the road, and we hope that you will consider voting for this petition on Monday. Thank you.
Just again, clarification if I can. So you said if anyone has MU1 zoning.
MU2.
MU1 right now, they would be wanting to switch over to an MU2, right?
Yes. Why wouldn't you?
Why wouldn't you? I mean,
I know, but I don't have that information right on my fingertips, but how many areas of the city are MU1?
There's like 3. But
3?
I would even argue it's not just MU1, and they may not want to just, I mean, what happens here, and this is what frustrates me, we could be talking 10 years from now. When I did zoning 12 years ago, now it shows up, nobody remembers the backstory, nobody remembers the decisions in the history. So 10 years from now, somebody comes up and says, you know what, I just want you to change this table of use entry to be MU2 on the map. That's all. We're just looking for that for a little bit of clarity. And you got a whole new set of people here, and they make that's how those things happen, right? So, but even if they don't change MU1 to MU2, somebody's going to say, wow, they got 2,000 square foot of density per unit. They got 21.8 acres. I want that in my residency. And there's nobody, these people bought industrial land. It's not like we owe them to rezone it to whatever they want. I mean, I bought Residence A. Yeah, I'd like to tear it down and put a 5-unit apartment in there and move, right? I can't do it, and I shouldn't have expectations to do it. So we don't owe anybody. You bought the land, you knew what it was zoned for. We helped out, we rezoned it, we promoted it, and we want to do what's right, but you don't owe anybody that. And so you're going to have people coming down here says going to put 2,000 square foot per unit density anywhere they can. They may not just say, I don't want, go to MU1 to MU2. They may just say, want to modify residential C. They may want to, modify the, add residential with that density to MU1. There's all kinds of things that could happen. You're setting a precedence that this is acceptable in the city by leaving this on the books, and I'm saying that's not something that I think is healthy for the city. Not by right. Definitely not by right.
Yeah.
I don't know how to say this. We have a problem with housing. I can certainly understand that this may not be the best location for high density.
Well,
housing,
the thing is, we are absolutely not against development. We have to grow.
Yeah.
We just have to do it responsibly. Okay? And there's a lot of acreage up there.
Yeah. That's why I was asking if it could be changed to something less with less.
If there's 17.9 acres, how about if they started that within the back? I don't think they would have had an issue.
Yeah.
But it sounds like you're not just talking about density, you're talking about transparency and community involvement.
Exactly.
And we know we need housing, we know we need to develop, but it's really important that everybody's involved so everybody knows what's going on and it can move forward efficiently. It sounds like that's what you're talking about.
I think that is, Councilwoman, what we're talking about. Responsible growth. Leominster for responsible growth. When you say we need housing, Councilman, you may have in your mind what we need. When I say we need housing, I may have a different vision. This particular project, which is not about the zoning that we're talking about, but this particular project doesn't solve either of those. It's a high market rate project that are going to rent for, it's not going to serve any of us. It's not going to serve our seniors. It's not going to serve to let people who want to age in place in Leominster move into somewhere that's safe, that they can then sell their single-family home so somebody can move up and those people can move up and then we have some entry-level house. It doesn't solve any of that. That's not what we're talking about. We're talking about, Councilor Noseworthy had said, all of us no longer have any say by right in what is done to roll out absolutely anything they want. And that, to me, does not seem why you serve. It does not seem to be what is correct when you have someone who is in charge of a housing committee who has a mission to rip the rights and the say and the voice of the neighbors away. I think you end up with a product that no one wins.
So zoning is about three things. We applied this rule all the time when we were reviewing this. Quality growth, protect the integrity of the neighborhoods, and protect the quality of life in the city. The last two were not part of this process. They weren't. And I would argue that, I know Ward 2 just went through a lot of pain in protecting the integrity of neighborhoods. This is not a single ward fight. And, that second part, that's what we're fighting for. Protect the integrity of the neighborhoods. I can tell you that if you allow a by right, and it's the most profitable development is going to be high density residential. That's where the money's going to be. Ward 1 is going to be affected. Not just the neighborhood, it's the most congested part of the city. Route 13, they've done what they could do. They painted some stripes, they put lights in. You know what the next work done on Route 13 to make it better is? Tear down the railroad bridge, fix the bridge over the Natural River. It's not going to happen in any of our lifetimes. It's as good as it gets right now. You're adding potential for 1,000 units. You're talking 1,500 car parking by right. That is going to infect the integrity of not just Harvard Street. I live in Ward 1. Anybody who doesn't think it's going to, People drive their kids to school. You go down Day Street, Johnny Appleseed has 15, 20 cars in the morning. They move the lines over because you're going to have to do it. Half of these units, in the 200, out of the 300 units, half are multi-bedroom. There's going to be children there. That's the style of apartments because families can't afford houses. They move into multi and they stay there. So you're going to have parents that are driving down Prospect Street, around the corner, and getting in to go to Johnny Appleseed to get in line on Day Street to drop their kids off. This will have an impact on Ward 1 and on the integrity of the neighborhoods in Ward 1. And it can't be by right.
It's the implications for impact is across the city. We're going to build, we will have to build more schools. Johnny Appleseed is really at capacity. Skyview is at capacity. We will have to add more public safety personnel, police and fire. We will have to, do we know that we even have the water capacity to take care of a subdivision this big? Do we have wastewater capacity at the wastewater treatment plant down off Mechanic Street? Well, we have to enlarge that. So these costs, Frank, they're not going to live in Ward 1. They're going to be spread out all over the city. So the impact, I think, is just tremendous. I mean, it keeps me up at night because with that kind of density and those kinds of numbers and those kinds of people, the cost, yeah, there'll be tax growth, there'll be some revenue, you know, coming in for the property taxes. But guess what? The costs of that development are going to far outweigh any growth that we're going to see.
You know, those are the questions I'd like to see, have somebody come down here and give us a definitive answer as to what are going to be the costs that we're looking at, because, you know, we are faced with a dilemma, you know, in Leominster. You know, we're land poor, to be quite honest. We don't have a lot of industrial growth or potential industrial growth. Mm-hmm. But we're also at the point where, you know, we need housing, and, you know, between, I guess, the MBTA zoning, mm-hmm. the ADUs, and who knows what's coming next down from the state. They're going to start forcing this stuff down our throat. We are going to be powerless, I think, to stop some of it. I don't want to become another Marlboro or something like that, but, you know, I just don't know that this change is going to stop that in the future. A lot of, I think, what ifs, you know, if it happens, you know. But
I think locally, to your point, though, this doesn't stop housing. It can still be done. It's just,
absolutely.
Everyone will be informed.
So what's the downside? What's the downside to passing this ordinance?
What's the downside? At this point, I'm not sure I see any. You know, I'm to be honest with you. I just don't know. But I'm just curious as to what the overall impact is going to be. That's all I'm asking.
What I'm asking is, can we reset the opportunity? Because I think we need another housing committee. I don't think the right people served. And, you know, I've sat through meeting after meeting where the letters from the mayor are read, where he rattles off all of the different times and opportunities that you had to hear what this was. And maybe there was, maybe we were, you know, not quite as in tune to serving on the housing committee because maybe we didn't understand what it was. I would absolutely suspect that you would have a lot of interest in residents of Leominster, not the developers, not a chairperson who wants to make sure neighbors have no input in it, but people who want to serve a housing committee, who can look at the numbers, who can look at the math, who can be realistic. If we do not serve our seniors and give them somewhere to go so they can live in this city, they're never going to give up their single-family houses. We do need affordable housing. We do need high-density housing to a certain extent, but this isn't that. And I do think it needs to be studied. So I do believe that this provides the opportunity to set back and say, this is not zoning. This is not what Leominster wants. It's not going to stop this project. It has nothing to do with this project. It has to do with setting the culture and the tone of our city and where we want to go for here.
Okay. I understand that. I mean, the thing that I dislike the most is the lack of input we've had, both from the citizens and from the council. You know that these decisions should have come before us way earlier, so that we could make some positive recommendations or negative recommendations. And I'm sympathetic to you folks up in North Leominster. They're going to have to put up with this project right now as it stands. And I just don't know that we're going to be able to really change it up in that area. I think it's going to still, it may have to come before the council and before the public, but that area is going to be developed, and it's probably not going to be developed in a way we like it developed, period.
Right.
Just, it's going to happen because, as, Bill said, MU2 is the most profitable type of development that's going to happen in Leominster.
It shouldn't have been. It should have been mixed use. Its name is mixed use, multi-use, and it should have been multi-use. And it's funny because you have to have rules in place to get industrial development to happen. Because nobody, if they have the right to go commercial or high-density residential or industrial, they're never going to choose industrial.
Right.
They're never going to do it. That's why the rule is in place. You can't have more than 1/3, right? We applied for a grant for a city to build a road to an industrial complex. That's what the road was built for. Shortly after that road's built for, the owner of the property applies to say, hey, take off the limit so that I can build this whole thing out residential. That's what happened, right? So this thing's been 25 years in the making, this zoning up there, under multi-use or mixed use. There's not 1 inch of industrial. And there surely isn't now. There might have been if you said 40 is the maximum that you could do for residential. Then you leave another 42 acres open, you got a shot at industrial. You have no shot now. It's not going to happen. And they'll tell you on paper it all sounds good. I'm not denying that. On paper, it could be built industrial, but it's not. 25 years.
There's no incentive for a developer to really look hard for industrial and to really work hard to bring those in. Frank, I voted for the MassWorks grant, the $2.1 million in state funding so that we could get that road built to the industrial complex, which it was, that's what it was supposed to be. That is nowhere to be found. It's the only thing that we see at the end of that road right at the moment, 308 luxury apartments. These are not, as Donna Millette said, these aren't going to help solve any kind of housing crisis here. And when I think about this, think about if you had all the detail that we have and we know what the development is going in, the density, the road out onto Harvard Street, all of the potential problems with, school expenses, public safety expenses, water, sewer, all of those problems that we're going to have to deal with. If you knew all of that back in January when the vote was taken, would you have voted for it?
Well, that's what I'm saying is that, I don't have that information as do we have the water capacity, how much additional fire and police protection we'll need. These are questions that I'd like to have answered before we vote on anything like this.
But you were voting on a zoning and not the project, right?
I know,
and it's still not the project, if I may just bring it back to that. This is an opportunity to reset the zoning so that we can figure out where we go from there.
I think those are valid questions, but I can't get up, because I also lived in the era where we made the decision to buy Sholin Farms. And it was almost $5 million of taxpayer money, grant money and whatnot. The biggest justification for spending that money was that this huge housing complex that was going to go in there, that was going to be 169 single-family homes or something on that scale. That was the justification, because let's spend this money, because if we don't spend it here, we're going to have to spend it on supporting the infrastructure that's needed to support that development. This place dwarfs 169 units. And in terms of taxes, and these numbers may be old, but it used to be that if you had 2.5 children, it was kind of a break-even point in a single-family home in terms of taxes you paid in services. Anything over that, you were using more services than your taxes. If you got 3-bedroom apartments, which are in these complexes, and you have 2 children, there's no way the taxes on a 3-bedroom apartment are going to cover the service costs for
2 kids in school.
2 kids going through the school system. And as I said, they're not spending thousands of dollars a month in rent to get an extra bedroom so they can have a little bit more space. They're going to have children in this. Half of them are more than 1 bedroom. So there will be an impact on infrastructure based on this. And I haven't done the math on the taxes, but I would be, this isn't a big tax revenue. The idea that this is some big tax revenue that's gonna be a win for the city. And one other my sort of pet peeve along that line, because this was we sold commercial as we need to develop Orchard Hills and Lowe's and all that because we needed mixed use, we needed commercial, we needed tax revenue. It was all about tax revenue. That was in 2003, 11% of the taxes from this city came from commercial. 78% came for residential. That's 2003, before the build-out. 2024, the build-out's done. We've filled the city up with all this retail. You know how much commercial pays in a percentage of the tax in 2024? 9%. They pay, we generate a lower percentage of revenue from commercial than we did before the build-out. Residents now pay 82%. Commercial pays 9%. Think about that. We were told this was a big revenue boom. Build all this commercial, you'll need it. Now we're told build all this residential apartments, it will generate all this revenue. It didn't work out that way. You know what pays the bills? The single-family homes that pay the bills. That's where your money is. The commercial is convenience. And this multifamily home, we need to establish housing. We all agree to that. But if you think this is a big tax windfall, given the services that you're going to have to provide, no way. I don't believe it.
I'm done.
Oh, okay. Anybody else have questions?
Just said quick.
Donna, I share your enthusiasm in wanting to get the public more involved in the input. One of the most moving moments for me is Ward 2. And all the people got together and got organized and really made their voices heard. I met members from the community, so many of them, so many more than I ever would have heard from. So I've met them and they got involved and they were really appreciative of what we did as a council. But the problem is that until it's a problem and it's brought into their day-to-day lives, people just tend to, they just want to go about their lives. They don't want to get involved in this. So I appreciate it, and I would love to see, that the Housing Commission come back and everything else. But the reality is, I know from Ward 2 that until it comes and they're faced with it directly, a lot of people are more hands-on. They want to go about their lives. They don't want to think about what we do. It should be run well enough down here that they don't have to worry about it. So, although, I get it and I appreciate it, I would love to see it myself. And I encourage everybody to do it, but I understand.
I learned a lot in 2025 about my neighbors. I've lived a quarter mile from Bill for the last 6 years. We never said hi before this year. So I think that, there's, it's a community. It is a community. We're a city. We are a great rural city. And I do believe when you have a lovely woman, Mary Ann, who walks the streets of Ward 1 gathering signatures. She knocks on my door. I've been seeing her walk by with her dog for years. We talk now. So I understand the apathy that comes. Believe me, I understand. And I have the same 24 hours that everyone else does. Whether it's medical, whether it's family, whether it's work, there's a lot more pressing on our days than going to 3 meetings this week, getting on Leominster Public Television. But this is important. This is important. And only when it was important for your ward, and maybe only when it gets noisy, the squeaky wheel got the grease. Right. We're asking that you make a decision to not let this be the problem in another district. When people figure out that the only way that they can make the most money is to ram that density down, and nobody's going to live there that can afford it. No one's from town. This isn't solving any problems. But I appreciate your understanding that I don't have time for this. Nobody does.
I think to the Ward 2 councilor's point as well, I as well want more people to be involved, younger people to be involved, the whole spectrum of people to be involved. The problem that I see most here and why I feel switching this back is important centers around the fact that we took that opportunity away for people to really have that voice. That special permit that was taken out in the petition 15-25 that we passed, that was the real place to have a voice. We've seen from the planning board meetings, you can talk until you're blue in the face on a site plan approval, but that only goes so far. So I think that I agree with you completely, Pauline, that, you know, people don't really get involved until it's in their face, but I guess I'm not a fan that we took that mechanism for people to be involved in a meaningful way away.
I think things have changed, to be honest with you, and I've been around a little bit. I think things are changing. I see young people that are involved. I see people that, you know, we all have lives, believe me. Orchard Hills has taken up more of my life than I ever wanted to even think of, but, you know, but I'm happy because I see people involved. And I do think there is crossover, because I know a lot of people in Ward 1 were supportive of the movement in Ward 2. It wasn't just Ward 2, it was a citywide involvement where people came out and supported Ward 2. And I'm starting to see crossover, you know, here. And I think there is a little bit more staying power, because there isn't a lot of land left in Leominster, and we got to do the right thing now to use what we do have. And Leominster has one huge leverage. We have premier highway access of North Worcester County, right? We have the premier access. We don't have to, I thought we should have forced anybody that wanted to come retail down here to do the mall, because it had the infrastructure to support it. And everybody, no, they won't do it, and then we let the sprawl happen, retail. Well, what is Costco showing us? You know what they're showing us is, Leominster's got such great access, we'll fix the mall and we'll make that investment. So the point is, we have leverage, real leverage, by having the premier access. We don't have a lot of land left. We can be a little bit, you know, about doing it right. Make sure we do it right. And you know what? If it's not this one, then it's the next one. But we have certain standards, and we have great leverage to say this is a great community with great highway access. Don't come in here asking for dreams, you know, your wish list of like the Wild West. Come in here with a reasonable offer, and you know what? We'll do whatever we can to help you. But we have access that, I mean, we'd be a different city without Route 2 and 190. We should leverage that. We should fully utilize that. That's our power.
Listen, I agree, but I think, I mean, we've gone a little bit everywhere tonight. And I get it, and I don't think there's anybody here that's going to disagree with that. I want a legal opinion. Where are we at? So we all can accept the fact that this is probably not going to have any effect on anything that's going on right now.
So in terms of the site plan that was approved, there's the statute, and I talked a little bit about this the other night. The statute was recently amended to say that site plan approval gets the same protection as other types of things do, like building permits and special permits. Has that been tested in court yet? No. And zoning things get tested in court all the time. But the consensus is that that will work the same way as those things do, meaning that because the application was made before this process to change it started, that even if it does change, that no, it won't affect that project that's been approved. Okay. There's been 2 subdivisions that have been applied for. The way it works with subdivisions is, if subdivision is actually the most lenient freeze or the most beneficial freeze to the developer, the way that works is you get 8 years if a definitive plan is approved. But the trigger for that goes back, and this was mentioned, goes back to when the preliminary plan was filed. So because the preliminary plan was filed before certainly any change made, unless there was some issue with, you know, assuming the definitive plan was approved, that's sort of the variable there. If the definitive plan is not approved, then you obviously don't get that protection. But if the definitive plan is approved, then you get 8 years going forward, so it wouldn't affect that either. But
There is a couple variables in there, and I'm not at liberty to discuss right now, but we really need this to be reversed, and it's not limiting growth. It's absolutely not limiting housing. Everything can be done.
Just on the, I don't know if you understand the scale to that point. By right, 223 units on 17 acres was by right under the old zoning. Now, you could have put a 100-foot buffer in there. You probably would have ended up with an apartment complex of 180 units. So we're not talking about, some chicken scratch. That's what the old zoning allowed. So it was substantial. The thing is, when you multiply it out times, the other thing was it was limited to 40 acres. So once you open it up to 82 acres, and once you open up the high density, now the complexity of both of those makes it this thing, off the charts. But the point is, 223 units minus a larger buffer and wetlands and whatnot, still was a substantial project. So I think that's important. The other thing is the clock on the preliminary subdivision is started for, he has to do a definitive subdivision. So what happens when we go to these planning board meetings, they talk about the other lots in this subdivision, and it's like, we don't know what we're doing. It's all up in the air. We asked for we made a plea to ask for a impact statement. Give us an impact statement on fire, police, school, all required by the Leominster's subdivision regulations, and the answer is no. We'll talk about what we want to do in the definitive subdivision, but right now it's all wide open. So the good news is that they were forced to try to protect their zoning by this petition going in. So now they're on a clock to produce a definitive subdivision, and I swear, I hope that we get an impact statement on a definitive subdivision, because that's what we should all be asking for. And the other important part of that is, in 7 months, they're going to have to come forward and say, hey, and keep this subdivision active, here's the real plan for what we want to do there. Now, if you don't pass this zoning and it goes back to the way it was, I think what's going to happen in 7 months when it comes time to put the cards on the table and tell us what you're doing with the other stuff, they're going to say, nah, we'll let that subdivision application expire because I don't got anything to worry about because the law says I can do it all. So, I think there's still some value in passing this and saying, hey, you better keep that subdivision open and you better give us some real definitive answers as to what's going there so we can plan for it. So I think that's value in terms, I think, am I right on that?
Yes, it's 7 months. In a word, yes.
Okay. So the point is there's value in passing this. That's another value in passing this. In 7 months, he could just tear this subdivision application up and say, no problem, I don't really want it that one, and then you come back and try to change the zoning again, and then he comes back and starts the clock all over, so you don't have any idea what's going to happen up there. This way, he's on a clock for 7 months to put forth what the real plans are.
I understand what the ward counselor was saying, that it is hard to get engagement unless there's an issue, but I do hope that is changing with these last two, big items that Leominster is looking at. And I think what's new is we've always worried about how to keep the elderly and veterans in their homes, but now nobody can afford a home or an apartment in Leominster. And I often hear people say we're a city with a small town feel. Well, we're not going to have a small town feel if nobody in Leominster can afford to live here, meaning those who graduate aren't able to even get an apartment or a house. So, I'm looking at all of that and hoping that people do get involved, and whether it's a housing committee or whatever it is, people start coming up with creative solutions, because even with these ADUs, not everybody has 200 grand laying around to create one. That's not another cheap solution for somebody who's graduating high school, or those people who have kids go off to college. When they come back, they won't be able to live in Leominster, and I think we really need to have some creative solutions, and the only way to do that is to have public involvement, and I hope people take that seriously.
I just, like you said, Dave, I think we really have to do the right thing here and go back to the way it was and go from there.
I want to say thank you to all of you. Believe me, I've been over there for a long time, and I know what it takes, and I want to say thank you. for showing up and asking questions. And thanks, Sue, for having us.
Yeah.
Well, you know what? This was the opportunity for the petitioners, us included, and all of you, to, explain why it's a really important thing. It's a really important petition. And, for the city councilors to ask questions. And we have our legal counsel here because we knew, legal issues and questions would come up.
Thank you.
Included you, yes.
Absolutely.
I was going to do a special one on the side over here. I was going to thank you, don't worry.
Yeah, but if does anyone in the audience have any questions that they might want to ask? No? Everybody's good? Okay. Anybody else? Pauline, you all set?
I'm good.
Frank? You all set? Carrie?
All set, thank you.
Okay. Brandon? All right. All right, well, thank you very much. Thank you very much for coming down. I know that everybody has spent a lot of time on
Thank
this
you.
and been to too many meetings this week. So on that note, the Legal Affairs Subcommittee meeting is closed. Thank you.
Thank you.
Thank you.
All right, you're welcome. You won't see me Monday.
Why not?